Good evening, afternoon, evening. Thank you, Raven. I appreciate it. And we'd like to thank the Jefferson Society for having us here to talk about this. So I'm going to start today, and I'm going to start my timer so I stay on task. So the reason that I am starting is because the title of my talk is Gender, Power, and Social Control. Because in order to understand what is happening in large-scale social interactions, you need to start with large-scale social interactions. So the subtitle is Dobbs v. Jackson and the Return of Women to Second-Class Citizenship. So let me start by just giving you guys some background on the way that I present. There will likely be cursing. There will be straightforward language. Some of that language is probably going to be disturbing. When you're talking about issues of abortion, you have to talk about gender, you have to talk about sex, you have to talk about rape and sexual assault, you have to talk about the denial of freedoms, all these kinds of topics that are really uncomfortable for us to address in this society, because our ideals, the values of our society, actually say the opposite of what we have found in the Dobbs decision. So I want you to understand that those are the kinds of things that when I look at these decisions that I pay attention to. Those are important factors when you're trying to figure out why large-scale social things happen, why laws get changed, why certain people are included or certain people are excluded. I would like to start by giving us, well, I already started. So let me go on to talk about some common vocabulary. So as I talk about this, I'm going to be talking about institutions, social institutions. Social institutions are structures in our society that govern our behavior. So education, family, religion, health and medicine, military, et cetera. Those are social institutions, and they are vital to our critical analysis of social interaction. Power. Power is the ability to exercise your will over others, even at their objection. So hundreds of thousands, millions of people are saying no, but you do it anyway. You have power. That's structural power. We're not necessarily talking about individualized power, because when we start talking about this, especially when we're doing large-scale analysis, people often want to kind of bring this discussion back down to individual power. Well, that person has the power of choice. That's not what we're talking about. Because in large-scale interactions, such as the Dobbs decision, an individual's choice has been taken away. So we're talking about structural power. Patriarchy. We live in systems. That's our whole existence, is in systems. Patriarchy is not man-hating. Patriarchy is a description of a social system in which being a male person or exhibiting male characteristics in a male-appearing body is prized. Okay, so that's a structural system that's not about individual people. Gender is also part of this social system, and how it expresses itself and how people are treated vis-a-vis gender is very much predicated on the kind of social system in which they live. So if you live in a patriarchal system and you happen to be a man, you're going to be prized. No matter where you are, where else you are in the social strata, your maleness is going to be prized. If you are a female person in a patriarchal system, your femaleness is not going to be prized. Intersectionality. So intersectionality, you've probably heard this word before. It's a word that is bandied about a lot. Here's what it means. It means when we're doing a social analysis, what we're doing is taking into account all of the major social factors and statuses that lie in a person, right? That sit in a person, that our society provides to them. So in my so I'm going to use myself as an example. One of my statuses is that I am a woman. Another one of my statuses is that I am Black. Another one of my statuses is that I am middle class, right? And so if people want to examine how my life trajectory has occurred in the scope of our large-scale system, you don't just analyze me as a woman. You don't just analyze me as a Black person. You have to put all of those characteristics into your analysis to understand a person's life experience. And that's what intersectional analysis is. And so that's the way that I think about the effects of Dobbs. And then there's this last one, woman, right? Because this is a political talking point. You can't even say what the definition of a woman is. Well, actually we can. But that's expanded so much more than what it used to be, right? Than even when I was a kid. I don't even have to talk about when I was a kid. 20 years ago, right? We had this very binary way of looking at men and women, right? The fact that we only talked about men and women indicates a binary system. A binary system of gender, a binary system of sex. So, woman can include sex. It can include gender identity. And when I am talking about a woman, I am talking about a woman who identifies herself as such, biologically, socially. So trans women fit into this, okay? All right, and so I also talk about this from the sociological perspective. And all those things I just talked about really are part and parcel of our culture. We got to Dobbs and the Dobbs decision because of the way our culture acts and enacts issues of gender. We got to Dobbs because of the ways in which our society structurally, through our institutions, oppresses certain people. So laws are not just made. They are made in our cultural context. So if in our cultural context there is a discussion about women being sub-male, right, second-class citizens, the only way that an institution can make choices has to do with the ways in which our culture expresses ideas about the subject matter that the institutions make decisions about. So in other words, if our culture prized people who identify as women as first-class citizens and equal to those who are identified as men, we never would have had the Dobbs decision. And that is a foundation that has to be addressed. We talk about it in terms of legal terms. We talk about it in terms of the ways it's going to express itself in many different types of institutions. But the fact of the matter is that if our culture saw women as equal to men, the Dobbs decision never would have occurred. It couldn't have. Our culture would not have allowed it. So what we are talking about is a large-scale cultural belief system that inhabits all of the institutions that govern our lives. So let's talk about how that expresses itself when we talk about law. So one of our really important values in our society is equality. There's a list of like 14 core US values, and among them is the concept of equality. So it is a core value to American culture. However, in that same culture, we have had from the start a history of oppression, right? That is long, that is detailed, that is a part of every nook and cranny of social life. So when we start talking about equality and justice and law, we often talk about them in very lofty ways. We talk about them as the ideals that we know them to be. What we have to do when we are examining Dobbs is we have to look at the reality of it. So there are 5 different court cases that have led us to Dobbs, that are significant, that have led us to Dobbs. There's Griswold versus Connecticut, which was in 1965. There's Roe versus Wade, 1972. There's Lawrence v. Texas, 2003. There's Obergefell, no, it's not a D on the end, Obergefell, versus Hodges, which was 2015, and then Dobbs in 2022. So I don't have a whole lot of time left, so I'm going to skip the specifics about them. So let's talk about some of the large-scale outcomes. So Dobbs takes away a woman's right to choose, right? That's pretty obvious. But some of the fallout that we are just now beginning to realize is starting to kind of bubble up to the surface. So one of the effects of Dobbs is that it affects the right to privacy. So now, if a woman is not able to choose what happens with her reproductive health, that's this thing. But the reason that privacy is a problem because in this thing, what the actual ruling was about was privacy. Roe v. Wade is not about abortion, it is about the right to privacy. So when Dobbs stripped Roe v. Wade, yes, technically, it stripped the right to an abortion, but it also, in a much more large sense, it took away, potentially, the right to privacy, which does not just affect women. It affects everyone, especially when we are thinking about this in terms of technological advancements and the ways in which we use our phones and our computers, et cetera, right? So now, right to privacy is at risk. We don't know now if we have a right to privacy, because in part, what Dobbs did was signal that we don't. All of us, not just women. Let's see. Let's talk about bodily restrictions. So Dobbs affects bodily restrictions. So what it does is it takes away from a woman her right to make decisions about her body, period. Right? And period is used there on purpose because one of the first things that happened after Dobbs was that privacy folks were like, shit, delete your period apps. Everyone, delete. There were chat rooms and threads on all forms of social media, videos on TikTok explaining that if you're tracking your period and your data is no longer private, then states can literally go into they can subpoena your records, right? And figure out when your last period was so that they could figure out whether or not you're pregnant. And if you were pregnant and you were no longer pregnant, where's the kid, right? There were schools that were considering asking parents to allow them to track their daughter's period data, okay? So we're not just talking about one thing. It starts to expand. And furthermore, so many states have so many different rules and regulations that they're putting into place, laws that they're putting into place. So we really have no uniformity. Oh, I had a couple of really good videos that I wanted to show you. Okay, and then there is beyond reproduction. So Dobbs, again, privacy, et cetera. But now, many states are free to go after contraception, and a lot of them have, right? So even over-the-counter contraception has been targeted to be made illegal. So that's one thing that, yes, you can technically argue that that has to do with reproduction or the desire to not reproduce. But we also have started seeing language and policy that doesn't have anything to do with reproduction. In the State House in Missouri, there was recently a law passed. When I say recently, I mean maybe 4 or 6 weeks ago, in which the women who serve in the House were legislated into a specific dress code. So women have to cover their shoulders and their arms when they come to work. No concomitant law for men, just women. Okay. So the importance of these types of laws is that what Dobbs has done is it has opened the door to the Wayback Machine. So many of these laws that we are seeing, we literally saw during slavery. So what do we do if a person leaves a state in which abortion is illegal and they travel to another state? What some of the states did immediately upon the Dobbs decision being handed down was started figuring out how state law enforcement would respond to stopping people if they were traveling through the state to get an abortion, right? That's the Fugitive Slave Act, right? The laws like what the Missouri State House passed are very much akin to Tignon laws, right? In which black women who were enslaved were legislated into covering their hair because it was too much of a temptation to white men. But legislated, they could not leave their homes without their hair being covered. So we're starting to see laws in effect or that people are proposing that are very similar to laws that we have seen earlier in our history that are specifically designed to restrict people who are already oppressed, to in fact oppress them further. Right? So I'm going to stop right there, and Dr. Fisher is going to actually now talk to you all about abortion rights, restrictions, et cetera. And we can talk about this after we're all done. We can have discussion. Okay? All right, go ahead.
Thanks. Good evening, everybody. Can you hear me okay? Yep, and on the mic too, you can hear me okay? Good, okay. Well, thanks for coming out. It's an unexpectedly snowy evening, and I know some of you are at home and did not brave the snow. Maybe that was a good choice. I just want to thank again Raven Clark and the Jefferson Educational Society, and of course my colleague and friend Dr. Rhonda Matthews. So we've been arguing about abortion for a very long time in this country. And that being noted, for the past half century, policy-wise, we've been living under an uneasy status quo, due in large part to the Supreme Court in Roe v. Wade and related decisions imposing constitutional boundaries, or in other words, restrictions on government attempts to regulate abortion. And that status quo under Roe v. Wade consisted roughly of the following: a fundamental right of abortion for any reason up to the point of fetal viability, which is about 24 to 28 weeks in the gestational process when a fetus can survive outside of a parent's body. After viability, states could, but were not required to, prohibit abortions. But even after viability, fetal viability, states could not prevent women from having an abortion in order to preserve her life or health, with those being very broadly defined. This is a pretty libertarian version of abortion policy under Roe v. Wade, and represented a big change from the prior 120 years in American history, roughly 1840 to 1960, when all states prohibited abortion almost entirely. And even with that relatively libertarian policy, states had a limited ability to regulate the process of abortion, but that was fairly strictly enforced, the limits on those processes. So the Supreme Court's decision in Dobbs in 2022 declared that there is not, in fact, a constitutional right of abortion, which in effect turns abortion regulation back to governments, mostly state governments, and the democratic process. And so now states have the freedom at this point in 2023 to ban abortion in part or whole, whether that's at a certain point in the gestational process or with a total ban, but with certain exceptions. States can also, or governments can also regulate what abortions are still permitted. And they can also determine who is punished and how someone is punished for breaking the law. So this turn of events may be to some of you thrilling, some of you it may find it terrifying, and you may find it somewhere in between, the effect of Dobbs. Regardless, Dobbs requires all of us to answer one fundamental question, and that is, if we, through the democratic process, are largely free to regulate or not regulate abortion, what do we actually want? What do we want to see in a post-Dobbs world when it comes to the regulation of abortion? So my sense is that how we answer that question, how each of us answer that question, whether and how we want abortion to be regulated, comes down to how we address three underlying philosophical, ethical, and political issues. And so I would call those three issues the personhood issue, the liberty issue, and the regulation issue. So let's talk about each one of those briefly. So the personhood issue involves the question of when and if we believe that the human creature gestating in a uterus, when that creature attains the status of a person, quote unquote, of independent and distinct value such that this person has the right to life, or specifically to be born. Pretty much everyone agrees, I think, that the fertilized egg or zygote or blastocyst or embryo or fetus is a genetically distinct human organism, a being that is inhuman in some fundamental way. For many people, being a human organism from conception automatically confers personhood. This something extra that marks one as part of the community of human rights holders. For many others, however, personhood does not occur until later in the gestational process or not even until birth. People may disagree on what they think are the minimum criteria for achieving personhood, various developmental milestones, for example. For many people, the abortion of an embryo or a fetus before a certain point in the gestational process is not morally problematic or less morally problematic, because what is being aborted, to their mind, is not a person who has attained the right to life. Sometimes people use the somewhat misleading phrase, I think it's a somewhat misleading phrase, life has not yet begun. Have you heard that question? When does life begin? And I think in an analogous way, and I think what they're really saying is we don't believe that there's a person yet. Not that there isn't a living human organism, but that there isn't someone who has attained personhood. So how we answer that question for ourselves, if and when an embryo or fetus attains personhood, doesn't end the inquiry when it comes to abortion. If we conclude that the embryo or fetus is a person deserving of the right to life, does that mean that the abortion of that person is always ethically wrong? Not necessarily. It depends on our view of a pregnant person's possible countervailing liberty interest. This is the liberty issue. Many people believe that even if at some point in the gestational process the embryo or fetus is a person, that person's right to life may nonetheless be overridden or outweighed by pregnant person's liberty to assert her interest in not continuing the pregnancy, and by extension be a parent to this eventual born person. Many people hold the view that the potential or actual burdens of pregnancy and or parenthood always or almost always confer on a pregnant person the ethical freedom to end pregnancy. On the other hand, many others hold the opposite view, that no potential burden from pregnancy or parenthood can justify overriding the unborn person's right to life, again, assuming that one believes that there is a person in utero at some point in the gestational process. And then for many other people, how they work their way through and then for many other people, how they work our way through this issue, or how we work our way through this issue. In other words, the scope of a woman's bodily autonomy, or person's bodily autonomy when it comes to pregnancy, is driven by the following question. In what contexts do we believe that a person has taken on or been assigned a duty or responsibility to care for another person, for example, an unborn person, and therefore does not have the right to stop caring for that person, for example, in terminating a pregnancy? This is the question of when we have a duty of care to one another. This is a common term that we use in the American legal system, the idea of a duty of care to others. So, having said that, note that in American law and in American society, we are not all automatically assigned a duty of care for each other, perhaps beyond having an implicit duty to actively avoid harming one another. So not all of us, for example, have the same duty of care to each other as a parent has to a child, or say a caregiver to a patient in a nursing home. But to that point, there are specific contexts under which we assume an ethical or legal duty to care for another, a responsibility that we are often seen as having taken on voluntarily. And even sometimes we take on the responsibility for the care of non-persons. For example, we have laws against a neglect of a pet, for example, or animals. Even though we don't see that animal as a person, we've taken on a responsibility that has ethical and perhaps legal consequences. So with this in mind, my suggestion is that whether one thinks that a pregnant person has a duty of care to a gestating embryo or fetus, so that there is not, in fact, a liberty interest in being able to end the pregnancy, depends on whether and in what contexts we believe that a pregnant person or a couple are responsible for the existence of the pregnancy in the first place. The idea being that the more a person is seen as responsible for creating a situation of dependency, the more they are seen as voluntarily taking on a duty of care for that other dependent person, and the less justified it seems for that person to abandon that duty of care. So I think the notion of responsibility is important here. You've probably heard someone say the following phrase, and you may or may not like this phrase. If you don't want to get pregnant, don't have sex. Have you heard somebody say that before? Let's translate that statement. Okay, what that statement I think is really saying is the following. The voluntary act of sex makes one have a duty of care to whatever unborn person is conceived as a result. Right? There's a connection there between the person's notion of responsibility and a duty of care. In contrast, I'm sure you've noticed that many people, not everyone, but many people who are anti-abortion, based on their belief that the embryo or fetus is a person with the right to life, may nonetheless, that anti-abortion person may nonetheless be okay with someone having an abortion when the pregnancy is the result of sexual assault. Now, why is that? Note that the circumstances under which the conception occurs does not alter the ontological status of the embryo or fetus. Our status as a human or a person isn't based on or grounded in the circumstances of our conception. So I think what explains this is that our otherwise anti-abortion colleagues see a victim of sexual assault as not responsible for creating the pregnancy in the first place, and therefore has not voluntarily taken on a duty of care for the unborn person. So even though the fetus or embryo is still a person according to that conception, they're okay with someone having an abortion, and they'd otherwise not be okay with that. So correctly or not, for many, their assessment of the level of responsibility of an individual or a couple for the existence of a pregnancy shapes their view of the proper scope of a woman's liberty to end an abortion, or end a pregnancy. Now, how we assess one's responsibility for pregnancy and continuing it is grounded in how we answer a whole host of other questions, which we would not have time to examine today or in a week or in a whole semester, about sex, gender roles, conception, consent, and responsibility. In other words, we sort of dive into this deep pool of these other questions that frame our understanding of when people are responsible for pregnancies and then perhaps taking on a duty of care for a gestating embryo or fetus. So that's the second issue, the liberty issue. So now we're to the regulation issue. And the regulation issue involves asking whether and how government power can be used to effectively and appropriately achieve a policy goal. If we believe that the embryo or fetus at some point in the gestational process is a person, And if we believe that the unborn person's right to life is not overridden by a pregnant person's countervailing liberty interest, so that we are essentially concluding that abortion is, in a given context, is unethical, is the use of state power the best method to address this unethical behavior? The answer might not automatically be yes, although for many of us we would say that it is. Okay? I'm not saying me, I'm just saying for many of us as a group. There are vast swaths of behavior a majority of us deem unethical in American society that are not illegal, in fact. Okay? And there are several reasons for why we do not always use state power to prevent unethical and harmful behavior. Really, we're wandering into sort of the realm of civil liberties here. Why do we have freedoms? And there's one reason is this regulation issue. Some behavior we consider fundamentally ethically contestable, as we simply realize that there's a critical mass or masses of us that cannot agree on whether behavior is ethical and should be punished or not. Some behavior is just not effectively controlled by state prohibitions. So you've probably heard gun rights advocates say that it is really impossible to effectively regulate guns. People who argue for the decriminalization or some or all drugs make, I think, a similar argument. It simply won't. Prohibition does not work. Right? State power is not effective in that context. Some behavior is hard to prohibit without negatively impacting behavior with which we are comfortable or we think is valuable. So, for example, free speech rights are based in large part on the inability to use a scalpel to cut out carefully the speech that we find lacking all value without indirectly perhaps burdening or chilling speech that we find quite valuable or important. Or some behavior that we consider harmful is best controlled or reduced not by prohibiting that behavior itself, but instead by focusing on addressing the root causes of that behavior. So instead of trying to control the symptom, per se, we address the underlying malady. So if you've ever heard someone declare that they are personally pro-life but legally pro-choice, it's possible that they are stating that they don't think that the banning of abortion is appropriate or workable. Okay? So how we think about the use of state power in regard to abortion, especially if we don't care for abortion, involves pondering in what contexts we think state power is effective, so we're really getting into questions of public policy, and in what contexts we are comfortable with state power being used to regulate behavior, really getting in the realm of political philosophy. So really, being a political science major, preferably at PennWest, is a great idea. So a little plug for us. So stepping back for a second, I think what we can see when we think about these three issues, the personhood issue, the liberty issue, and the regulation issue, is that we probably hold a much wider diversity of views on abortion than is commonly characterized by activists and in the public discourse, right? This sort of binary pro-choice and pro-life. This is because there are multiple positions that we could take within each one of these issues and multiple combinations of views across these issues. When personhood takes hold, if at all, during the gestational process, in what contexts we have a liberty interest in ending a pregnancy, which again taps into all these deeper questions regarding duty of care, responsibility, sex, gender roles, gender and power. And in those instances where we find abortion ethically impermissible, whether and how we think state power is the most appropriate and effective means of reducing or eliminating unethical abortions. Now, having acknowledged that there are a diversity of views, in terms of policy, there are many polls that indicate there's a rough consensus, American consensus, about how we'd like to see abortion regulated, although one would not necessarily know it from current law or the popular discourse. If we proposed a national law, and I'm not saying this is a good idea or a bad idea or something in between, but if we proposed a national law that said that abortion would be legal for any reason within the first 12 weeks of gestation, generally impermissible in the second 12 weeks of gestation, however, with three big exceptions: life or health of the pregnant person, fetal deformity or fetal demise, sexual assault or incest. And then after the point of fetal viability, abortions are generally prohibited with a narrower exceptions basically for physical life or physical health. You might have about 2/3 of Americans signing off on that. And again, I'm not saying that's correct or incorrect, but there is, in some sense, an American policy consensus. However, we don't see it in American policy or law, interestingly enough. So with all that in mind, I have 4 brief observations about the road ahead. And if you want me to elaborate on each one of these, I'd be happy to do that during our conversation after I'm done speaking. So the first observation is that the policies articulated in most state laws and by pro-life and pro-choice activists do not represent the views of a critical mass of Americans. And I believe that this is due in large part to gerrymandering of legislative districts, which produces more politically polarized legislators, but also political polarization itself as a larger phenomenon in American society, which I think has really plagued us in the last 10 to 15 years. These two things, in my opinion, cause abortion regulations to be more, quote unquote, extreme than what many Americans want. In other words, what we tend to see is an oscillation between quite libertarian abortion policy or quite restrictive abortion policy, and not something that really represents, I think, probably the bell curve, the top of the bell curve of American opinion. And I think also gerrymandering and political polarization have blunted the effects of the predicted pro-choice backlash to the Dobbs decision, right? The sort of a general idea was that when Dobbs occurred, oh my goodness, Republicans and pro-life legislators are going to take a beating. And did that occur? Kind of, but I think not nearly to the degree that people predicted it. And I think the Democrats, to the degree that they overperformed in the 2022 elections, it had to do with as many things not related to abortion as it did to the Dobbs decision. So that's the first observation. Second observation is that in part because of the influence of gerrymandering and polarization on democratic decision-making, state Supreme Courts and state constitutions will become the sites of intense focus in the next several years as perceived avenues to break gridlock or extremism around abortion. Observation 3 is that medical abortion, that is, abortions caused by taking medications, so mifepristone, methotrexate, misoprostol, will be a key focus of abortion politics in the next several years. And just a small public service announcement, and Dr. Matthews was kind of pointing to this, medication abortions are abortifacients. They are medications that are meant to end an existing pregnancy, whereas things like the morning after pill, emergency contraception, and so on, those are contraceptives. They are intended to prevent a pregnancy from occurring, and that's a very common misconception that the two are the same, and in fact, they're in fact different. And the last observation is that if we hope to avoid continuing frustration over the current state of things, we need to talk to each other more subtly, I think, about abortion. And that involves talking more about the personhood, liberty, and regulation questions I discussed a few minutes ago, but also about ways to achieve abortion reduction, not simply abortion regulation or prohibition. What we may find is that effective means to reduce the number of unwanted pregnancies and concomitant decisions to abort pregnancies end up being more impactful and desirable than a regime of abortion libertarianism or abortion prohibition. And I actually think there is also, despite extreme polarization in this country, some possibility of consensus around the reduction of abortions rather than simply the prohibition of abortions or widespread permissive regulations or non-regulations around abortions. Okay, so those are the ends of my remarks. Thanks very much, and I look forward to your comments and questions.